Hello, good afternoon, everybody. You're very welcome along to our session this afternoon on corporate governance for owners management companies. David Rouse is my name, advisor on multi-unit developments with the Housing Agency. We're delighted this afternoon to be collaborating with the Chartered Governance Institute, ICSA. We're very pleased to have Conor, Sweeney and John Burns from the ICSA with us, and we'll introduce them more formally in a number of minutes. I'm going to share my screen and just go through some housekeeping and background for you. Our timetable this afternoon, we will have a number of polls throughout the session. I'm going to do a little bit of a background and introduction on owners management companies in the sector. And about 20 past 12, we'll hand over then to Conor for his presentation. About 20 minutes, 25 minutes after, we will have a Q&A, and we'll aim to wrap up and close by 1 o'clock and keep to the timetable as best we can. Just in terms of housekeeping, you're probably all very familiar now at this stage with Zoom and how it works. We have the Q&A function at the bottom of your screen. If you hover at the bottom of your screen, you'll find the Q&A section for your questions, and please use that for questions. And if you'd kindly use the chat function for any problems, you have my colleagues Katrina Lawler and Mary Coffey are in the background on this afternoon's session, and Katrina and Mary will be keeping an eye on the Q&A and keeping an eye on the chat function. So if there's any problems with sound or vision, you can drop a line into the chat function. And as you know, the session is being recorded for future use. A little bit about the Housing Agency for those of you who aren't overly familiar with our work and where we are. We're just on Upper Mount Street near Merrion Square. We work with the Department of Housing, Local Government and Heritage, as it is now since last weekend. We work with the local authorities, and today is, conscious that today is your council day, so we have a number of people from the local authority sector on today's session. We work with approved housing bodies and other stakeholders in the sector to promote the building of sustainable communities. Our guest this afternoon, Conor Sweeney, founder and managing director of CLS Chartered Secretaries. We're delighted to have Conor with us this afternoon. I'll be handing over to Conor shortly. And John Burns, business development manager for the ICSA in Ireland, is with us as well. And I'll maybe hand over to John for a couple of words. I'll stop sharing my screen now. So we're delighted to hear from John and what CBI are up to.
David, thank you very much indeed. And the Chartered Governance Institute we're delighted to be joining the Housing Agency for this important webinar this afternoon. Yeah, we've been quite busy supporting our members, I suppose, in the last 3 to 4 months, supporting them from the regional team here based in Dublin and also from our colleagues in London. We've had to cancel a number of our planned events because obviously face-to-face communication hasn't been an option. So we've replaced that with virtual webinars and also issuing more guidance notes to members. And we've also been involved at the start of the lockdown, I suppose, in making representations to the company's registration office with regard to the availability of certain services. And I think you'll have seen in the months of April and May an improvement in what the Crow have been offering, and that's good to hear. We've had some webinars on AGMs, obviously an important topic from the governance perspective. AGM season tends to be April, May and June, so we've had some webinars on how to run AGMs under the current difficulties, virtual meetings, how to run those, directors' duties, how boards manage in times of uncertainty, proactive approaches to governance as well. And we've also issued guidance notes on AGMs and also electronic signatures. And we would have also shared some more guidance notes written by our members in their own firms on general guidance for company secretaries, preparing financial statements, directors' duties, cybercrime, and so on as well. Just at this stage, I'd like to point out that we have a webinar coming up on Thursday, the 16th of July. That's tomorrow, 2 weeks. We have an update from the Registrar of Companies. So Maureen O'Sullivan and David McFadden will be joining us to share with us what's going on in the Crow at the moment. And they'll also be covering off the new filing system and the e-filing that's happening at the end of the summer. So that could be of interest to many people on the call today. Details of that are on our website. So there's a slide there for me, I think, David, which has my email address and also my our website. So if you go onto that, you'll find details of all of our events, and the 16th of July event is there. Yep, icsa.org.uk/Ireland. And also, if anyone is interested in becoming a free subscriber and getting email updates, news of our events, accessing any of our free resources, if you follow the link on the top right-hand corner of our website, you can enroll there as a free subscriber, and that is naturally free of charge. So just make sure you mark your preferences to receive emails from the Institute. And if anyone has any interest in becoming a company secretary or wants to find out more about the routes to qualification, drop me an email. The address is there, jburns@icsa.org.uk, and I'll pick them up next week, and I'd be happy to spend time with anyone who's interested in taking on some of our examinations. So look, David, I think that's enough from me at this stage. We're really looking forward to the webinar, and I'll hand back to you at this point. Thank you very much indeed.
That's great, John. A busy time for the ICSA in Ireland, despite the lockdown and the situation. I think everyone has really risen to the challenge of what's been presented to us over recent weeks and months. What I might do now is very quickly launch a poll, because I'm conscious we have a very diverse audience with us this afternoon, and this is an anonymous poll, so we just really want to get a sense of who exactly is on the session with us. So if you kindly let us know what your sector is, and the question is, what best describes your relationship to owners management companies? So company secretary, OMC director, management agent, OMC member, legal advisor, accountant, auditor, local authority personnel, or some other category. So we'll just run this very, very briefly, and I'll share the results with you shortly. But as I say, this is an anonymous poll, so please do feel free to submit your answer there. And I'm going to end that now shortly. So thank you very much to everyone who let us know on that. It's just useful to get a sense of our audience. And so that's the balance, the rundown of people in the sector. So thank you for letting us know. I'm going to share my screen again and go through a couple of other points. As I mentioned at the start on an earlier slide, you can contact us at mud.housingagency.ie for a copy of the slides or for any other queries on this session. So please do get in touch with us on that. Conscious also, as I mentioned, that we are now in phase 3 of the roadmap for reopening society and business, and to frame the content for this afternoon's session and be conscious of the prominence or the precedence taken by government and government health and public health guidance, and that's all available for you on gov.ie. Why are owners management companies important? I suppose many of you who have been on our earlier webinars will know some of this, but Census 2016 says that about 205,000 people were living in apartments or multi-unit developments, certainly around that time, about 205,000 apartments rather, and 500,000 people. The stock of apartments in the country has gone up by about 85% between 2002 and 2016, and whatever again has been built since then has been a considerable growth in the MUD and the OMC sector. Apartments now form 35% of stock in the Dublin City Council area, so it is the largest component of the housing stock in the city. And there's a significant component of local authority stock within the owners management company remit, if you like. Estimates of the number of OMCs, somewhere between 6,000 and 8,000. It's difficult to track through the system at the moment, but we're doing some work on that. And of course, while we talk about apartments and multi-unit developments and being managed by owners management companies, the sector extends beyond that. So we have conventional houses and normal housing estates, maybe that don't even have apartments in them, but they do have an owners management company running common areas such as green spaces or facilities such as waste collection. So the owners management company is a thread through the housing stock, and it's increasing in number over time. Here we see planning applications from 2001 to 2019, and this is a recent slide prepared by the CSO, and you can see the apartment stock rising, the green line at the bottom, and it has more recently outpaced houses in terms of planning permissions. And of course, within that housing element, within the conventional housing component of housing stock, you would have, as I mentioned, stock in owners management companies. So we are all in this together. Collaboration, a constructive approach to owners management companies makes for harmonious multi-unit developments, harmonious communities, sustainable communities. Many of you will have seen this slide before, and what we're focusing on today is the area really in the red box. The owners management company itself, the relationship of the OMC with its members, the relationship of the OMC with its directors, and how those relationships interact. And Conor is going to touch on in some detail, in fact, on the law underpinning all of those relationships. An OMC really is more than a company, however. Again, it is the basis of sustainable communities in multi-unit developments. It's a residents association in some respects, because the directors are typically people who are living in the estate in many cases. It is a not-for-profit entity, company limited by guarantee, that Conor will touch on, but ultimately it is a property or an asset manager. And that is, I suppose, the unique nature of the OMC. It's a property manager, an asset manager, but run by volunteers on a not-for-profit basis. So it's helpful to bear that in mind. So Conor's going to touch on company law, on other aspects of law, including the Multi-Unit Development Act. And we shouldn't, I suppose, forget the Property Services Regulation Act. And I suppose one aspect of that is that the Property Services Regulator recently issued a consultation on new minimum standards to be observed by management agents. And that focused on, I suppose, the interaction between management agents, OMC directors, the services to be provided, and whether there might be some alteration or change in the context of company secretarial services provided by management agents. So that's, I suppose, something to look at. The regulations haven't been issued yet. They're still in the pipeline, but that's a further, I suppose, context to this session, and to focus on the importance of the company secretary role in an owner's management company. It's key really to the smooth running of an OMC, and perhaps the recent RBO Register of Beneficial Owner exercise late last year might have, I suppose, delivered some turbulence to owners management companies, and maybe support was required around that. So Conor will certainly touch on that. You'll all be familiar probably at this stage with our report on owners management companies, and I think Conor's going to touch on some of the recommendations out of that in the context of OMCs. And equally in the UK, the equivalent entity in the UK to an OMC is an RMC, a residential management company. And certainly anecdotally in the UK, RMCs were typically the company most likely to be struck off the company's register. And that was probably the experience in Ireland, maybe certainly 10, 15 years ago, and in the teeth of the crisis and the property crash at the time. A lot of turbulence around OMCs and developers and so on is obviously considerably improved, and compliance rates are a lot higher, but it's a consistent experience. A note quickly about the apartment planning guidelines and the requirements to consider a building life cycle report in a multi-unit development, but also to consider compliance with the MUD Act, to establish an owner's management company, and to consider the legal requirements both on the MUD Act, from the MUD Act point of view, and from company law. In terms of our own resources, you'll be familiar probably at this stage with our website and the links we have available. Maybe not familiar to you is more recently issued guide for multi-unit developments and OMCs, a collaborative effort by ourselves and the Housing Agency, the Institute, or rather the Society of Chartered Surveyors Ireland, and the Institute of Professional Auctioneers and Valuers, and we're very grateful to those professional bodies for their collaboration on that. All this information is available on our website, and if you haven't seen our fact sheets issued earlier on this year in the early days of the COVID crisis, there's information around governance and finance for OMCs as well. Some writing we did in indeed the Chartered Governance Institute's professional journal, Governance and Compliance, focused on OMCs and residential management companies. And Nick Kisson in Lease Advisory Service in the UK was a contributor, a co-author on that article, so it might be useful for some of you. More recent webinars that we've hosted are all on our website. So we had sessions in relation to company finance, operational considerations of multi-unit developments through COVID-19. They cover a lot of the day-to-day management issues, service charges, operational matters, essential services. So we'd encourage you to visit our website for those. A quick point on the programme for government was that there's a commitment to review existing management company legislation and whether it's fit for purpose, so possibly focusing on the MUD Act. So we're going to watch this space on that one. Again, if you wish to contact us, mud@housingagency.ie, and we can revert to you as soon as we can on any queries you might have in relation to this session or anything else on the sector. So before I hand over to Conor, I'm going to very quickly run a second poll, which really will help us with future work in the sector. And I'm going to launch it now, and hopefully you can all see that. So the question is, based on your experiences, please select the biggest challenge for OMCs during the COVID-19 period. So is it collecting management charges? Is it holding meetings? Is it enforcing house rules? Delivering estate services? Or perhaps COVID-19 has not impacted OMCs at all? Or is it something else? Don't know. And please let us know your views. Again, this is an anonymous poll, so we won't know how you voted, but we'd be delighted, please, for your feedback, because, as I say, it'll help us understand future needs in the sector. So about 65% of you have voted, so we'd encourage you to take the time and take the chance to vote. We like to think that we have pretty interactive sessions, and again, it will just be useful for future reference and to get an understanding of how the sector is managing through what has been a very disruptive, certainly a disruptive period for all of us. So look, I'm going to finish that poll, and I'm going to hand over to Conor shortly. So I'm going to anyone who wants to quickly get a last vote. We're at 74%, so if we got one more person to vote, we would have the equivalent of a special resolution. I think if my company law memory is right, Conor, on that one. So one more person to vote. There we go. Now we're up to 75%. So I'm going to end that poll, and I'm going to share the results. So here we are. Wow, holding meetings, 35%, by far and away the winner, if you like, on that one. Next up was collecting management charges. After that is something else, don't know, so that's something we might look into at a later date. Enforcing house rules next, delivering estate services, and COVID-19 has not impacted. It's about 3%. So thank you all for participating in that. Very, very useful and very helpful. And I'm going to close that poll, and I'm now going to hand over to the main event, if you like. Conor Sweeney, Managing Director, Founder of CLS Corporate Services, Corporate Secretaries. We're delighted to have Conor with us today. Grateful for his time and for the Institute's time in organising Conor as speaker. So I'm going to hand over to Conor. I think, Conor, you can share your screen, and you're in control, as it were. And I'm going to take.
Great. Good afternoon, everyone. Thank you to David and John for inviting me to present on a topic of owner management companies, which we could probably spend all day doing. But I'm based here in a rainy Carlow, so thank you very much for everyone for jumping on today. What I want to cover over the next 45 minutes, and hopefully give a bit of time for Q&As, but I'm hoping I've covered a lot of the queries people have been having, and interesting from the poll there. Most people's issues are in relation to holding meetings, be it directors or members meetings. So you'll be glad to know we're not going to cover that at all in this presentation. Only joking. No, we're going to cover looking first of all at company constitution for owner management companies. We'll look at what annual company secretarial compliance is. So for any company, but particularly owner management companies, what is the main things that you have to do from a company secretarial perspective to keep your company compliant? We'll look at those general meetings, which is one of those points, and passing resolutions and voting and all the challenges companies have before pre-COVID-19 in relation to holding these meetings, but also then the impact of COVID and how we relate to those. We'll look at common changes in owner management companies, from directors, changing the constitution, that kind of thing. I've put in directors' duties. Not going to spend a huge amount of time on that, but I'm going to leave it in there for your reading, just in relation to fiduciary and statutory duties. The interaction of the Companies Act with the MUD Act. I'm going to cover this in every part, because there's no point in talking about the quorum or this or that, or resolutions or the annual report at that particular section without mentioning both. So I'll do that throughout the course of the presentation, and also just give you a mention in relation to the Company Registration Office and the role of Director of Corporate Enforcement, particularly in the whole area of disputes and issues that come up with owner management companies. So the first thing to look at when we talk about owner management companies is, what's the two pieces of legislation that underpin owner management companies? And I'm looking at this very much to the lens of company law and company secretarial practice. So the two pieces of legislation that we're looking at is the Companies Act 2014 and the Multi-Unit Developments Act 2011. So when we look at the Companies Act, the majority of the companies that are owner management companies are set up as companies limited by guarantee without a share capital. And the reason they're set these companies up is because companies limited by guarantee, or CLG, are set up not for profit. They're used as representative bodies, and you have members as opposed to having shareholders. And that makes it some way easier in relation to running your company and running the owner management company. So a couple of things just to note in relation to that is, first of all, establish what company type it is. The odd time you might see maybe a DAC, a designated activity company, or an LTD company set up as this owner management company. But in the main, the majority of them I think we see in the register are companies limited by guarantee. The important thing to note in relation to those is they need to have in the name company limited by guarantee, or the suffix CLG, and the sections of the Act that we're looking at are sections 1172 to 1226 of the Companies Act. They're the ones that specifically deal with companies limited by guarantee. The Multi-Unit Development Act, as you're probably aware, is the law specifically for the operation and governance of residential and mixed-use developments. I just wanted to touch, because this is what I will try and focus on through the course of the presentation, of what are the key challenges, and interesting, the poll underpin this, is holding meetings, be it directors meetings and member meetings. And while these are important, is the three main reasons we see it is the approval of the annual report and the financial statements, the re-election of directors, because the majority of these CLGs will have what's called retirement by rotation, and finally is the approval of the annual service charge, because as we'll see later on, this has to be approved by the members of the company in order to be levied. So that annual general meeting particularly plays an important role in relation to management companies. The other thing all companies have to do is file annual returns at the Company Registration Office. As you might be aware, the Company Registration Office introduced an exemption for companies to file their annual return up to the 30th of June. That was extended to the 31st of October. So what that means for all companies is they have until the 31st of October to file their annual returns and the financial statements. And if they do that within that filing period and that extended deadline, then the company is deemed to have filed on time, which could be an important thing maybe for audit exemption particularly. The last thing just to look at, and it's kind of linked back to the first point, is company constitutions need to be fit for purpose. And we'll cover, in the first point, we'll cover over, what things should be considered to be included in your company constitution and important things to look at. So if you aren't aware of, haven't had a chance to review what the Multi-Unit Development Act covers, the main things really when it was introduced back in 2011 was, first of all, the requirement to establish owner management companies, the provision for the sale of the units and the transfer of ownership into the common areas, which needs to be done prior to the sale of the first unit. There's regulations here in relation to mixed-use multi-unit developments where you have a mixture of residential and commercial, and we'll cover that. A big thing for company law and for us is the automatic membership of the owner management company for all the unit owners, how you automatically become a member as soon as you, a unit is transferred into your name. One vote is attached for each residential unit, and we'll see where that can play an issue in relation to a conflict between the Companies Act and the MUD Act. The requirement to hold annual meetings and the annual report for members and the time frame in relation to when that needs to be issued. It provides for the scheme of annual service charge, establishing a sinking fund, making house rules, disputes and resolutions in relation to how that they can be dealt with. And that's all quite useful, and again, things that should be considered to form part of your company constitution. The last thing, particularly from a company secretarial perspective, is if an owner management company has been struck off. You will have 6 years then to make this application, but there is some provisions that you need to be aware of in order to satisfy those rules regarding the 6-year restoration. Otherwise, you're into the High Court, which is a lot more expensive. Very helpfully, the MUD Act gives some definitions, and I've just included some of the main ones that we might reference throughout the course of the presentation. Childcare facility, commercial unit, common areas, developer, mixed-use multi-unit development are all included in its definitions. So residential unit means a unit in the multi-unit development, which is being used for self-contained facilities, or is designed for used as a childcare facility. Unit owner means a person other than the owner management company who holds the highest freehold or leasehold estate or interest in respect of the unit. A multi-unit development in itself, what does that mean? And that means a development being land in which there stands erected a building or buildings comprising of not less than 5 residential units. Now, the MUD Act does provide for situations where you have between 2 and 5, but it's primarily focused on residential developments with not less than 5 residential units. It does provide for mixed-use multi-unit developments, and this is often where you get a couple of questions, because the Act is clear, it's one vote per unit. But what it does provide for in multi-unit, multi-use, multi-unit developments, how do you calculate service charge, sinking fund contributions and votes? And what the Act does provide is that they're applied in a fair and equitable manner. So when you're preparing a constitution, particularly for a mixed-use multi-unit development, you really need to have clarity on voting, how that's done, contribution to the sinking funds and all of that. And there's some guidance out there in relation to how those may be calculated. Is it based on floor space or whatever else? But I would encourage you to make sure that your constitution does provide for that. An owner management companies means a company established for the purpose of becoming the owner of the common areas of multi-unit development and the management and maintenance and repair of such areas, which is a company registered under the Companies Act. So it does have to be an LTD, a DAC, a CLG, but as we said at the start, it's a CLG is typically the most common company type, and that's what I'm going to base my a lot of the guidance on today. So when we're looking at what rules that applies, obviously we're looking at the Companies Act 2014, as we said, and we're looking at the Multi-Unit Development Act. But one of the documents that's specific for your company is your constitution of the company, or what some people call your memorandum and articles, or your arts and memos. But that's the document specifically for a company. And it's divided up into 2 documents, particularly if it's an LTD or if it's a DAC or a company limited by guarantee. It's made up of a memorandum and an articles of association. So it's important to understand the difference between the 2. Your memorandum sets out the objects and powers, you know, what the owner management company is set up to do, what its objectives are, what its powers are. And then the articles of association are the internal rules and regulations of how you meet, notice periods, proxy form, rights of members, that kind of stuff. So they're 2 different documents, both very important, and both of them should be very specific for an owner management company. So a couple of things I just want to highlight in relation to constitution for owner management companies. First thing is the name. So the name should include any companies incorporated after the Act was commenced in 2011 should have owner's management company in the name. And its suffix, since the Companies Act 2014 came out in June 2015, should have company limited by guarantee or CLG as its suffix. Okay, that's the first thing to note in relation to its name. The next thing then is the objects clause, and it needs to be specifically for the operation of an owner management company. And the MUD Act sets out some guidance in relation to what those activities are. But again, you should make sure that they're broad enough powers to include the operation of an owner management company. And you should also include the name and the address of the development to make sure it's specific for that particular development. If you've Ashfield owner management company, it could be anywhere in the country. So you want to make sure it's specific for that owner management company. And sometimes you might have different owner management companies in different developments. So is this for Block A or Block B? So you should have one specifically for the area that it manages. Additional objects and powers should be included also in the Memorandum of Association. Some of the things that you may include are the appointment of management agents to assist with the running of the owner management company. And also you'll see in some constitutions processing of personal data of unit owners and disclosing payments or non-payments of service charges and sinking funds. So again, that's something that might assist owner management companies in the area of GDPR and dealing with unit owners and tenants and the whole disclosure requirements and stuff like that. So again, seek some advice in relation to that, but including that power in your memorandum might be useful. The liability of members then is typically €1. So what that means is in the event of the company going into liquidation, the members are liable. They have limited liability, but it's a limited amount in your constitution, and that's typically €1. But again, never assume, always check what it is stated in your constitution. So they're the main provisions that are included in your Memorandum of Association. It's the Articles of Association that are probably a lot more detailed, because the Articles of Association draw on the provisions of the Companies Act, particularly Part 4, and these provisions specifically for companies limited by guarantee. And they deal with the meeting rules, notice periods, all of the internal rules and regulations regarding running a company. And no different to an LTD, a DAC, a PLC, or whatever else. And what we find is the constitutions for these companies limited by guarantee and owner management companies should be quite detailed, because it's the governing document that companies will use to run their company. Now, I don't even have a copy of the Companies Act. It's outside in the office there, but you know, the Companies Act is 1,440 sections long. So to save companies delving into that to try work out notice periods and proxy forms and stuff like that, the Constitution should include those rules. So you should be able to have a Constitution that sets out the rules in relation to directors' meetings and member meetings, members' rights, how do you become a director, how do you become a member, how do you cease to become a member. Those should be all in your Constitution, and they should be taken into account the provisions of what's in the Companies Act, but also in the Multi-Unit Development Act. So I've referenced throughout some of the sections that we're going to cover, particularly now, and looking at company meeting rules. Either the Companies Act, where I just referenced the section. If it's referring to the MUD Act, I'll have MUD Act, Section 8 here, for instance, in the MUD Act. And just to give you a bit of guidance on where those sections will come from. So the first thing to look at is in relation to the automatic membership. And typically what you would have in your Constitution is that membership is confined to the subscribers, who are the original members when the company is incorporated, and the unit owners. So as soon as before the first unit is transferred, the common areas need to be transferred in, and then when a unit owner has a unit transferred into their name, they automatically become a member of the owner management company without the need to execute a transfer or have it approved by the board of directors of the company. So again, the first thing you need to look at, what is your company type? We're going to assume here it's a company limited by guarantee. So then you automatically become a member of the company limited by guarantee, or the OMC, without the approval of the membership. The MUD Act provides that a membership cert needs to be issued as soon as practicable, and that the register of members needs to be updated. So again, one of the requirements for a company and for the board of directors is to maintain a statutory register of members, and we'll touch on that a little bit later on. So again, it's a document we find in practice that's issued, you know, the register is issued when the company's been incorporated. It might have got handed over from the transfer over to the directors, but it is a statutory register that needs to be kept updated. The unit owner is required then to provide certain information to the owner management company and to notify them of any changes in these particulars. And this is often an issue we come across, is, you know, and you often get queries and questions of how do you keep in contact with these unit owners? What happens if they change address or contact details? But the obligation in the MUD Act is on the unit owner to make sure that you keep the owner management company up to date in relation to your particulars. Section 14 of the MUD Act sets out one vote shall attach to each residential unit in a multi-unit development to which the owner management relates, and no other person has voting rights in respect of such determination. Now that's quite clear, and that's quite useful that it sets out one unit per or one vote per unit in the development. However, there is a potential conflict between the Companies Act and the Multi-Unit Development Act, because if you examine the provisions under the Companies Act, it's one member, one vote. Whereas under the Multi-Unit Development Act, it's one unit, one vote. So if I am a unit owner and I'm the developer and I have sold 10 of the 30 apartments, but I still retain the majority of the units in the development, do I have one vote or do I have 30 votes? Okay, so you need to be, the Act needs to be clear in relation to it. Is it one member or one vote? And if companies haven't updated their constitution or made it specific for a multi-unit development or owner management company, there will be that conflict, and we've often got queries and questions in relation to it. So if that hasn't been updated to reflect it, and you are an owner management company and the Multi-Unit Development Act applies, then you need to make sure that the constitution is updated to reflect this. Another common provision that you'll see in the Articles of Association is no member shall be entitled to exercise a vote in respect of a unit at a general meeting or signing a written resolution unless all monies payable to the company, including any service charges, income on contributions in respect of that unit, have been fully paid. So again, we have a lot of practitioners here from the ICSA. So if we're asked to prepare documentation or attend the AGM and work out what the voting is, again, it's making sure if that provision's in place, we need to establish who is actually entitled to vote at that meeting or not. The annual service charge, I'm not going to go into massive detail in relation to this, only there is one or two important points that practitioners need to be aware of, or our directors do, and that's Section 18 of the MUD Act sets out an owner management company shall establish as soon as practicable a scheme in respect of annual service charges from which the owner management company may discharge ongoing expenses. And again, the Act sets out what those kind of expenses are. Where it is important from a company law and company secretarial perspective, and this is particularly an issue in relation to COVID-19, is that the annual service charge shall not be levied unless it's been considered by a general meeting of the members concerned to call for that purpose. Okay, if the proposed service charge is disapproved by not less than 75% of the persons present and voting, the proposed service charge shall not take effect. And that's again just important wording. It's 75% need to disapprove in order for that service charge not to be approved. It's not 75% need to be approved, 75% need to disapprove it. Okay, and that's an important provision. Instead, if it has been disapproved, the charge applying for the previous period shall continue to apply pending the adoption of a service charge for the period concerned. If disapproved and no service charge applied in the previous period, the directors may determine a scheme for a 4-month period. So that's particularly important in relation to what we're going to go on and look at company meeting rules. But again, it's probably something, because it is required and because there's particular voting requirements in relation to approving this annual service charge, we'd always encourage these provisions to be made open and clear in your constitution and how they are going to be dealt with. And that's the exact same thing in relation to the sinking fund. So Section 19 of the MUD Act sets out an owner management company shall establish a sinking fund for the purposes of discharging expenditure reasonably incurred on the multi-unit development. And the Act is very clear in relation to what would that expenditure be it of recurring and non-recurring nature. And it gives a guidance helpfully to directors of owner management companies on how to do this, setting up a separate bank account, all that kind of stuff to deal with it. What it does provide is the owner of each unit shall be obliged to make a contribution to this sinking fund. The amount has been set in the Act as €200, or such other amount as may be agreed by a meeting of the members. So again, it's either €200 a default position, unless the members agree it's going to be a larger or a smaller amount, but it has to be approved by the members in the company. So again, from a company secretarial and company law and the board of directors perspective, this needs to be approved by the members of the company. So again, I would encourage that to be included in your articles of association. Setting of house rules. So again, something that can cause particular issues in owner management companies, particularly larger organizations, and how you set those rules. An owner management company under the MUD Act is required to may make house rules as respect to the development or part of development, to enhance the quiet and peaceful occupation of its units in the development. House rules should not be made unless the rule have been considered and approved by a meeting of the directors. Not less than 21 days notice is given to each member of that meeting. Okay, and the house rules, if been approved by the members, need to be sent out to all the unit owners and obviously to those tenants, so they're aware of what those house rules are. But again, from a company secretarial perspective, it's important that it's approved at a meeting of members and not less than 21 days notice has been given. Directors, there's provisions in the MUD Act in relation to directors. From a company law perspective, just to reiterate, the Companies Act requires 2 directors. One of those directors may act as company secretary. However, depending on the size of the multi-unit development, will determine how many directors you will need to carry out the activities. Typically, it's quite difficult to get people to act as directors of owner management companies, as we're all aware, because people are taking on a lot of issues in relation to owner management companies that they might feel comfortable doing. And you don't just have, it's not like a residents association where you're just trying to sort the issues from to deal with the association, but you've a company law requirement, and when you sign up as a director, you've legal obligations to act in the best interest of the company. And that's why we set out just towards the end of this presentation what the fiduciary and statutory duties of those directors are. So that obviously it can be a difficult role, or it can be a role again, a lot of the time is about clarity, being clear in relation to what people's role and responsibilities are, what the members are entitled to do, what the directors are entitled to do, and the role of the management agent. And the more clear and clarity you can have in that role, that minimises the potential issues that can come up. So just in relation to directors, as I said, you need 2 directors in relation to the company. the MUD Act provides a person shall not be appointed as a director of an owner management company for life or for a term greater than 3 years. Okay, if this situation existed, then the director must have resigned within 3 years of enactment of the MUD Act. So again, this is just a look back. If you have been a director of a multi or an owner management company, you've never retired by rotation, you've been on the board for longer than 3 years, then this is something that you need to be aware of. And again, something that should be included in your constitution. Often we find the challenge is the directors 3 years are up, they're trying to get off the board and they can't get anybody onto it. So again, with one hand, you might have another challenge of trying to get other directors onto the board. The last thing I just want to mention is in relation to contracts, and the Multi-Unit Development Act sets out provisions in relation to how long you can enter into contracts for, and it can't be in excess of 3 years from the date of contract that entered into by the owner management company. Again, contracts are quite important for board of directors in relation to potential conflict of interest and whether you can vote in favour of those contracts, but also the provisions regarding what's in the MUD Act, that they cannot be any more than 3 years. So that's what sets out the key provisions we think should be included in a constitution for an owner management company. But again, you need to make sure, if you haven't updated your constitution in a while, make sure that that has been updated or take steps in the next while to do so. Just in relation to annual company secretarial compliance and what it is. So prepare and file an annual return, hold directors' meetings, improve and sign a set of financial statements, hold an AGM, maintain the statutory register and minute book of a company, and comply with disclosure requirements. They're a key thing for all directors to do. And the last thing, I'll just mention it briefly here now, is update the register of beneficial owners, which is a requirement that came out last year. And it's up to companies to determine who the beneficial owners are, be it the members, depending on whether they satisfy, they own more than 25% of the voting rights, which will again go back to whether it's one member, one vote, or one unit, one vote. If not, the senior management officers may have been disclosed, which means that's the board of directors. So if you do a change of directors, that will also have an impact in relation to register of beneficial owners. So one thing just to remind all companies is, if they haven't made that owner management, that RBO filing yet, please do so. I know the Morning O'Sullivan has, as registrar, has said that they haven't commenced proceedings against companies that haven't filed, but they will be looking to do so in the near future. So please, if you haven't done so, or if you haven't updated because there's been a recent change, you to do so. One question that comes up quite a lot is in relation to the question of audit versus audit exemption, and whether a company should be audit or audit exempt. And often members give out about the cost of having an audit, or even paying for the audit exempt accounts and stuff like that to be done. Just from a company law perspective, a company limited by guarantee may avail of audit exemption if it's under the audit exemption thresholds, which most audit exempt or owner management companies would fall into, or even some of the very large ones. However, because most of them are companies limited by guarantee, the rules in relation to audit exemption is one member may object. Okay, so what we mean by that is, if the company intends to avail of audit exemption and you notify the members that, look, to save cost or whatever else, we're availing of audit exemption, and we feel that we can run the company successfully and produced financial statements that are true and fair without the requirement to have an audit done, then they might want to wish to avail of audit exemption. However, as members have the right to object, and they need to object in writing 1 month before the financial year in which the exemption is to be availed of. Now, the challenge with that is it's only one member. You could have 300 members, but one person comes along and says, we must have an audit, then the company must, unless they sit down and explain or talk to that member, otherwise the company will still have to retain an audit. And it's interesting, the Housing Agency report that I'll touch on briefly at the end, one of the recommendations in that is that owner management companies cannot avail of audit exemption, that they must have an audit. And you can imagine why, if I'm paying service charges and you want to have clarity on where the money's been spent, that an audit is being done to give clarity to those members in relation to it. Holding company meetings, as we saw, this is something that a lot of companies are trying to understand what the rules are, first of all, pre-COVID. Forget about what the meeting rules are in relation to companies. And again, your constitution should set those out and be clear in relation to what the notice periods, proxy forms, what the rules are. So you should consult the Constitution, the Companies Act, the MUD Act, and obtain legal advice prior to holding company meetings, because in light of the physical distance rules that the government had set out in relation to social distancing, you may not be able to hold these meetings. And that will have an impact in relation to holding the AGM, retirement by rotation. Will those directors' powers cease if the AGM is not held? The approval of the service charge, the sinking contribution to the sinking fund, as I mentioned, all those have to be approved by those members. So if it's not done at the AGM, then, or the AGM is not held, then those provisions might not be looked at. So when we look at holding company meetings, be it board meetings or member meetings, or looking at the physical meeting, can we hold a meeting electronically, or we could be passed off by written resolution. For us, for member meetings particularly, written resolutions for owner management companies don't really work, because you might have quite a large number of members and it might be very difficult for all the members to sign that written resolution. So then you're looking at, can you hold a physical meeting with social distancing or whatever else? We'll try to cover off those rules now. So in order for the look at the company meeting rules, you need to look at electronic meetings, who's the power to convene, the notice, the location, the proxy forms, particularly for member meetings, the quorum, the chairperson, the voting, and the minutes. They're the different items that you need to examine, and we'll just, conscious of time, just look at some of these briefly. And as I said, you have set out the various sections in the Companies Acts that they rely on. So the board meetings are governed under parts 4 of the Companies Act, sections 157 to 167. The important thing to note in relation to these is they can be amended into your constitution. So again, you can amend these provisions, something like the quorum of members is 2. If you wanted the quorum of members to be 5, that could be amended in your constitution. The first thing to note in relation to electronic meetings is for directors, it is provided for under section 161. And the meeting, a meeting of the directors can consist of a council call between some or all of the directors. But once everyone can participate, they should be counted in the quorum and be entitled to vote. So it's very clear they can participate. And the location of the meeting is where the largest group are, where the chairpersons are located, or the meeting decides the location. Who can convene it? A director can, or the secretary instruction of one of the directors. All the directors are entitled to reasonable notice. And a quorum, as I said to you, is typically based on the Companies Act is 2. But if you have a sole director, which doesn't apply to an LTD company, or only applies to an LTD company, it's 1. The chairperson, so the chairperson may be elected per meeting, or they may be elected for a period of time, typically for a 12-month period. Voting, questions arising shall be done by a show of hands, and each director has 1 vote, and the chairperson may have a casting vote in the event of a tie. Again, that might be something that's disapplied in your constitution. So again, that should be checked prior to the meeting. Written resolutions, so is provided for under section 161. Instead of having your meeting, if you want to put the text of the resolution, it would have put to the directors' meeting, have that signed by all the directors, then that is deemed to have been approved once all the directors sign that written resolution. Minutes is something that I could spend a good hour talking about minutes, lack of minutes, what goes into them. The style guide, I would say ICSA has some very helpful guidance on their website in relation to minutes and minute taking and the format of those minutes. So I would point you in the direction of that after this presentation. But the important requirement for a company is under section 166 that the company cause minutes to be entered into books kept for the purposes of resolutions and proceedings of all meetings of directors and committees of directors. Okay, so you need to make sure that minutes are kept, that they're signed by the chairperson as the prima facie evidence of those minutes. The Director of Corporate Enforcement has specific right to access this book if potential issues come up. So that's just very quickly in relation to directors' meeting minutes and the rules around holding meetings for directors. Members' meetings is where we probably see a lot more queries and questions in relation to holding meetings and what are the requirements are, because obviously the larger body, you probably have a lot more members than you do directors. So you have a lot more issues that you have to contend with. So what I point you to, first of all, is the Companies Act Part 4, Chapter 6, that deals with the rules in relation to holding member meetings. Typically, you have 2 types of member meetings. You have an annual general meeting, which is your statutory requirement, and then an extraordinary general meeting can be held if you need to pass a special resolution or an ordinary resolution. So if you wanted to adopt a new constitution, for instance, during the course of the year, you could do that at an EGM. You can also pass resolutions by way of written resolution, but again, as I said, that might be quite difficult. The more members you have, the more difficult it might be to get written resolutions passed. So something that a lot of companies are struggling with at the moment is the requirement to hold an AGM. And Section 175 of the Companies Act provides a company shall in each year hold a general meeting as its AGM, and not more than 15 months since shall elapse since the last one. And Section 17 provides an annual meeting needs to be held once in each year for the consideration of the annual report. So it is a requirement for all companies to hold an AGM or an annual meeting as referred to in the MUD Act once in each calendar year. And the question that we have is, can we hold these meetings electronically? And the Companies Act under Section 176 provides that a AGM can be held electronically with a reasonable opportunity to participate. However, what we have seen is it doesn't provide for, unless your constitution specifically provides for electronic voting, you can participate but not vote electronically in your constitution unless your constitution specifically provides for it. So this is something that a lot of companies are trying to work out. Can we hold an electronic meeting? Do we use proxy forms to allow the members to cast their vote? So, and we'll look at proxy forms in a few moments. Or what way do we do it? Or can we hold a meeting with social distancing, depending again on the number of members that you have? But again, what I would advise you to do before you send out your notice for your AGM is to consult your constitution, review that constitution, and see what it does provide in relation to holding electronic meetings, in relation to electronic notice, and also whether you can participate and vote electronically, or do you have to use proxy forms, or will you have to adjourn the meeting and reconvene it at a later date when we might have less rules regards social distancing. The location of the meeting is provided under 176, but can be held inside or outside of the state. However, Section 17 of the MUD Act states it needs to take place within reasonable proximity of the MUD Act and a reasonable time unless agreed in writing by 75% of the members. Now that could prove a challenge if you're trying to hold an AGM with social distancing, but it can't be held in a reasonable proximity of the multi-unit development. So again, you might have to have it in a car park or something like that. But again, these are factors that you need to consider when choosing the location, given the current restrictions that are in place. The directors can convene an extraordinary general meeting, but also members have the right under Section 176 and 1203 of the Companies Act. If they have not less than 10% of the total voting rights, they can requisition a meeting to be held, and it's up to directors to consider whether that EGM should be held or not. Again, social distancing rules will need to be considered in relation to those. The notice period, the notice then, so the notice of every general meeting shall be given to every member, person representative, the signee of a bankrupt, and to the directors and secretary of the company. So they're the persons entitled to receive notice, and also the auditor should be given notice of the meeting also. Electronic notice. So if you want to electronically communicate, it's provided for under Section 218 of the Act, okay? And this is an optional provision, but your constitution needs to provide for how that is going to work, okay? And whether the members have opted in to receive an electronic communication or not. Now, obviously, given the current environment, it could be quite difficult to send stuff out by post or get stuff signed. But if you want to communicate electronically to your members, the provisions need to be included in your constitution in accordance with Section 218 of the Act. So again, I would encourage you to review your constitution if you're hoping to rely on those provisions. The notice periods, the minimum notice periods are set out under Section 181 of the Act, and that's 21 days for the notice of an AGM, or 21 days if you're holding an EGM at which a special resolution is going to be passed. Okay, 7 days notice needs to be given for a shorter meeting, or for an EGM for an ordinary resolution. So the first thing when you're giving notice out, you need to work out how much notice period needs to be given. Okay, the contents, again, you need to set out what's going to be discussed at that meeting, the place, the date and the time. In the case of the proposed special resolution, the text of that resolution. But, you know, depending again what you've decided to do, if you're going to hold the meeting with the minimum number of members, that you'll be encouraging maybe just the directors are going to attend that EGM, and that you encourage your members not to attend in person but to execute their proxies. The standard business at an AGM is set out under Section 186, and again, something we come up quite a lot is the confusion between the role of members and directors. The members only consider the financial statements of the company that have already been approved and signed by the board. So it's the board of directors' job to approve and sign the financial statements. It's up to the members to consider those financial statements. So it's not the members' job to approve a set of financial statements. And we often come across this confusion of, oh, it's up to the members to hold an AGM to approve the accounts. That's not the case. The members just consider those financial statements. There's an opportunity for the members to review the company's affairs. Declare a dividend doesn't apply in relation to for a company limited by guarantee, because there's no share capital. Authorization of approving the remuneration of statutory auditors and reappoint the auditors if it's an audited company. If it's an audit exempt, it doesn't apply. And the last thing is retirement by rotation, which is something that's in the constitutions for companies limited by guarantee, and that's where 1/3 of the directors longest in office have to retire and offer themselves for re-election. And that's why it's quite important for an AGM to be held shortly or to be held in the year, because otherwise the directors may cease to hold office. Other items that need to be considered at the owner management company AGM, Section 17 provides that a copy of the annual report to be furnished to each member will have to be sent out 10 days before the meeting. Consideration of the annual service charge, as we saw earlier on, that needs to be approved by the members before it can be levied. And consideration of the contribution to the sinking fund. They're all the provisions that should be considered at the owner management company. I've just set in some of the provisions of what needs to be included in the annual report. The quorum then, no business shall be transacted at a general meeting of a company unless a quorum of members is present. Safe to the extent the Constitution provides otherwise, it's 2 members of a company present in person or by proxy. So first thing I would say to you is review your Constitution to see what the quorum requirements are in your Constitution. That might have been increased to 5 or 6. It could be all of the members of the company. Again, we've seen various different things. But the first thing you need to work out is what is the minimum number of members in order for the meeting to proceed to business. So if it is 2, then you require 2 members present in person or by proxy, so where a proxy has been executed. So what you might see is where you encourage the members to give their proxy vote to the chairperson. So at least if you have 2 persons there, one of the director maybe being the 2 of the directors, and then you give your vote to the chairperson, and you might participate by maybe a Zoom call, but your vote has been cast under your proxy form that has been given to the chairperson. So again, there's various different things, and what I would do is, as John mentioned earlier on the ICSA's website, there's some very good guidance in relation to, in the blog section of the ICSA's website, where guidance has been given in relation to electronic meetings and what we're seeing in practice, particularly the area of PLCs, but they're also quite useful for owner management companies to understand maybe the blend of allowing members to participate by Zoom, but that they cast their vote using a proxy form. But again, what I would encourage you to do is review your Constitution, first of all, to make sure that you're aware of what those rules are in relation to proxies. The rules in relation to proxy forms are set out in Section 183 and Section 1205, and this entitles anyone who's a member of the company to appoint another person to attend the meeting or to vote on their behalf. So again, quite a useful provision. One thing to note for companies limited by guarantee, it is an optional provision. So again, check to make sure it hasn't been disapplied in your Constitution. But the second thing is it can be quite useful in the current environment to encourage the members to execute the proxies to the chairperson of the meeting, so then their vote is used at that meeting by proxy as opposed to turning up at the meeting itself. Proceedings at general meeting, the chairperson of the board shall preside as the chairperson at every general meeting. Resolutions are typically done on a show of hands, and if there's a quality vote, the chairperson may have a casting vote in the event of a tie. Again, you just need to be very mindful to see and check the Constitution to see whether that has been disapplied or not. We mentioned about the voting when we're looking at the Constitution of a company and Articles of Association. So again, just having clarity on, is it 1 member, 1 vote, or is it 1 unit, 1 vote? And whether, if you haven't paid up your service charge or your annual service charge, whether you're entitled to vote in relation to that. Members do have a right to demand a poll, which is the chairperson or 3 members present in person or by proxy, or members holding not less than 10% of the voting rights. The last thing just to mention in relation to meetings is under Section 199, minutes are required to be kept, a bit like what's provided for under section 166 for the directors' meeting. And any such minute, if reporting to be signed by the chairperson, shall be evidence of the proceedings. Just in relation to the right to inspect, members have the right to inspect the minutes in accordance with section 215 and 217 of the Companies Act 2014. It's the same rules regarding inspecting the statutory register and the minute book of the company. I'm very conscious of time, guys. I don't know where the time has flown. I'll just cover a couple of last things and I'll hand back then to David. Couple of things that we just come across in relation to types of members' resolutions. So again, when you're looking at a company, we would always encourage companies to determine, is it an ordinary resolution or special resolution that is required to be kept in relation to, or to be passed. So you've got to check, is the decision required to be approved by the directors? Is it required to be approved by the members? If it's required to be approved by the members, is it an ordinary resolution or is it a special resolution? So then if it's an ordinary resolution, it's simple majority of the members. If it's a special resolution, it's 75%. But also the MUN Act contains some of the resolutions have to be passed either by a simple majority, which is 50%, 60% or 75%. So always you've got to ask the question is, what is the decision that has to be made? Who's the power to make those decisions? I mentioned earlier on about written resolutions. Probably not useful if you've any more than a couple of members. It's important to make sure it's the EGM is probably a better route to go than trying to get all the members to sign that's written resolution. And majority written, just be careful, are not provided for companies limited by guarantee. It's only unanimous resolution. That means every member would have to sign it, hence the difficulty of those being done. Just very briefly, common changes in relation to companies. If I could only reiterate one point, anyone here that's in practice will understand this, but with lay directors and stuff like that, filing a CRO form does not give the proposed change legal effect. Just because you file a B10 in the Company Registration Office doesn't mean that I have been appointed or resigned as a director. Okay, you need to establish the necessary resolution that has to be approved either by the directors or by the members. Then the statute register needs to be written up to date, and then the necessary form needs to be filed in the Company Registration Office. And that's regardless of what the change is. Okay, it doesn't have legal effect until it's approved by the appropriate person. So appointing directors, first thing I'd say is check the Constitution. Typically it's a matter for the members, but the board do have the right to appoint a casual vacancy. And again, you need to check whether they have to retire at the next AGM if they're appointed by the directors and what those rules are. But as I said to you, the B10 filed in the CRO is the last step in the process in relation to doing this. Ceasing to act as a director is something we get a lot of queries on. If you're resigning as a director, you need to resign in writing. Okay, so you need to get a letter of resignation from the director, resigning in writing, and trying to make sure they've no past or future claim against the company. Removal of a director is something we get a lot of queries on as well. There might be a dispute. The one thing I would encourage you to do is get legal advice before anyone pursues this avenue, because this will cause a huge amount of issues. And there is a specific process under section 146 of the Act that must be followed in relation to the removal of director. The appointment of a company secretary is a matter for the board. I would encourage to make sure people are aware that the secretary has the necessary skills or resources to carry out or discharge his or her statutory duties. So when the board is appointing directors, they need to make sure that they have those necessary skills. The resources is where they might point somebody else to act as company secretary, but they've engaged someone like CLS or the accountant or solicitor to assist with those. I've mentioned about the Constitution. Again, it's a special resolution. The last thing I'll just mention is in relation to owner management company restoration. It's 6 years that you can do an administrative restoration where you apply to the High Court to have, or apply to the Company Registration Office to have the company restored. The important thing to remember in order to get the 6-year restoration is the common areas must have been transferred into the owner management company prior to it being struck off. So if they weren't transferred in, you end up going into the High Court, and you do need to get a certificate from the accountant or solicitor certifying that it is an owner management company, and that criteria has been established. I've set out the duties and responsibilities there. I'm unfortunately hot for a huge amount of time here in relation to that. So if you do have questions in relation to it, they'll be handy for the guidance. Just in relation to Director of Corporate Enforcement, the Director of Corporate Enforcement only focuses on company law breaches and not in relation to breaches of the MUD Act, regulation of management agents, or service charge or debt recovery, whatever. So again, it has to be in relation to a company law issue that might be in play in relation to it, but there's some very useful guidance in relation to it. And I've just set out some of the, I'm going to be doing an article for ICSA in the next couple of weeks just on some of the recommendations that have a company law impact in relation to owner management companies that we've seen. I've set out just some essential advice in relation to directors. Get advice before acting is probably, and consult your constitution is probably if I was to summarize, David, what the important things for directors is understand your constitution, take advice in relation to it before calling meetings and stuff like that. But apologies for running over, but hopefully that has been somewhat useful for everyone on the webinar today.
Fantastic, Conor. Comprehensive doesn't do justice to that session. I know we've had loads of questions, and I've been typing away in the background answering some of the questions for people. I think the one main one that I've seen come through that I'll just highlight is on serving as directors. And I think if I'm right, the main question that has come through is if someone has served 3 years and retired by rotation, can they be a director again? I'm right in saying that they can go ahead and be a director again after that. Yeah,
once they cannot act to it, they have to be re-elected then after that. So that's where the retirement rotation comes in, and it links to both. So yeah.
And again, another question that came in: someone can serve as 3 years, disappear off, and come back and serve another 3 years after a period. So there's no problem.
Typically, your issue is normally trying to get someone to replace. If the directors want to leave.
Absolutely, succession planning is always part of these things as well. Another quick question that came in, and I am conscious we're slightly over time, but people have stayed with us because I have a fantastic presentation. So one question that came in was, can you advise me if a receiver can attend and vote at an AGM? And I think a receiver is really, their interaction is really with the debt on a property rather than with the owner's management company. So my instinct would be that they don't have a vote. Would that be right?
Yeah, that's my understanding. They don't automatically become a member because there has been a change of ownership. So then it's the unit owner still has the right to attend and vote at that meeting, not the receiver.
Great stuff. Look, I think we'll try and wrap it up there. There's lots of questions that come in, so if people can email us mud@housingagency.ie, and I think we'd be delighted to come back to people individually on questions. I'm going to wrap it up. I'll maybe hand over to John for his last comments. John, thanks very much
David,
again for the collaboration.
Much. Can I just thank you very much for the opportunity to work with the Housing Agency today. We're absolutely delighted. And Conor as well, thank you so much for your expertise, for sharing your wisdom. And again, the proof of the pudding is over 30 questions submitted. David and the team really fast at answering them. There's still a few hanging out there, but look, thank you so much for that. And can also thank Mary and Katrina from the Housing Agency for all their work behind the scenes to make sure that this worked well. Thank you.
Thanks, John. Again, from our own perspective, Conor, we might hand over to you. Any last words of wisdom or thoughts?
Yeah, no, apologies. I didn't get to the Q&A. I was hoping to try to cover as much of potential questions might have been had, but look, we'd be happy to answer any of the questions you send on to David. And if people do have queries, contact David, and they can pop us an email here either, and they can sign up to our newsletter on our website or the ICSA as well, because there's a lot of guidance up there as well, as I mentioned. So, but thanks a million for having us. I really appreciate it.
Great. Thanks a million, folks. Thanks for your time. We'll wrap it up there. Very grateful to John and his team, to Conor and his team in the background, to my colleagues Mary, Katrina and Michael McHale on our communication side. Look, we'll say stay safe and mind yourselves during the difficult times we're having. So thanks very much indeed, folks, and take care.